Hello everyone, hope you all are doing well. Welcome to this international seminar and conference which organized by the University of the Jain. That is my pleasure and honor to be here. That's why first uh, that is necessary. First, I convey my special thanks in regards to the organizer of this session, the University of the Jain, Dr. Rabia Timsamani, and her colleagues, and all of you as a participant in this session. I'm Dr. Ehsan Jahanian from Iran, the expert and researcher on maritime law and the law of the sea subjects. Today, I want to talk about the application to rendering assistance to the distressed individuals at sea, and also the particularly application of shipmaster in this context and existence of challenges in this regard. For continuing, please attend to the PPT, then I will explain and continue the presentation. Thank you for your consideration. Thank you. Rendering assistance at sea, legal duties, and practical dilemmas of shipmasters. The sea has been associated with insecurity since earliest times. Thus, the beneficiaries and stakeholders always attempted to improve the safety and security rules and have been trying to reduce hazards at all times. Consequently, the history of maritime illustrates that improving safety comes only gradually over time in the wake of events. Hence, search and rescue operations and rendering assistance to crew and passenger and individual and property in distressed situation is not new issue. It's widely known as an unethical attempt and due to protection of individuals, including of crew and passenger lives at sea in the distressed situations. Nonetheless, in response to bunkering issues, development of technologies, and rising costs and competitive in shipping markets, and growing marine disasters since the end of the 19th century onwards, the major maritime powers sought to enter into international conventions and treaties to ensure the shipmasters helped to the distressed people at sea. Consequently, from early of 20th century, this customary international obligation was formally accepted in the international conventions. In this regard, the Salvage Convention in 1910, Collision Convention 1910, and then Solas Convention 1914 were the first international convention which codified related regulations which imposed the obligation of rendering assistance to shipmasters. Although this convention established the shipmaster duties in this context, but exempted ship owners from liabilities for failing to providing assistance to distressed ships and individuals at sea. So I want to examine the shipmaster roles and its challenges under international law and in practices at sea, and also the potential disciplinary action against the shipmaster in case of failing or omission to the rendering assistance to distressed individuals at sea. The authority of the master in a historic perspective. The position of the shipmaster was dominated by the rule by monarchy, and that his position was comparable by the king and the land. And the ship, the master held the same position and power as an absolute ruler would have on land. In his dealing with the crew, he was solely considered to be responsible only before God. So the shipmaster, same king, was exclusively accountable to God. The shipmaster was responsible for advancing the work and also discipline on board the ships. And the result of this situation was the seafarer exhibited total loyalty and obedience to the master. The order and discipline on board were nearly military-like. The master had the power to impose punishments and administer justice on board. The goal was to control the ship during a prolonged stay at sea by including fear among the crew. This view changed since the 19th century. The role of the master changed for first time. The master power and his position on board changed, and as a representation of God or King similarity shifted as a father on board. However, with development and codification of laws in both stages of domestic laws and also emerging of international law and new convention and in international instruments, captain position entitled rights and also have a responsibility now. Apparently, these changes have occurred due to the beginning of discussion between multinational parties over the protection of interests in sea trade. However, assisting these distressed the people at distress at sea was one of the first international customary obligation that shipmaster had to follow under these international instruments also. One question arises for you: what is the shipmaster duty at sea and domain of the rights and responsibility in our era? Always traditionally, trust to shipmaster was especially high because shipmasters are experts with appropriate experience. Therefore, even with technology advancement, the importance of the master roles extended and reflected to the various international maritime instruments to ensure the safety and security at sea, and also on this ground, I can refer to the As an example, in the International Safety of Life at Sea, the SOLAS Convention, the main maritime safety instrument, in its chapter 5, Regulation 34, the banning the ship owners or the charter or any other person to intervene intervene the master decisions for conducting safety navigation and his professional actions because for protection of the maritime safety and protection of marine environment. So as we can see, nobody can interfere against the operational decision of the shipmaster at sea during the sailing and also even the operations. And also that is the particular because the shipmaster are already aware about the vessel characteristics and maneuverabilities of the vessel and also his personal abilities. On the other hand, these rights and trust also has liabilities for the shipmasters. Under United Nations Convention of the Sea and Clause 1982, Article 94, for example, the state shall effectively exercise its jurisdiction and control over ships flying its flags in all administrative issues, technical issues and social aspects. Accordingly, the shipmaster and officers shall qualify under known international standards and ask that the master and officer shall follow all international regulations and standards related to the safety and protection of marine environments, training standards, and watchkeeping, etc. Or under Article 97 of UNCLOS, the flag states and the origin nationality state of person can impose penalties and or take any disciplinary action against anyone who commits misconduct or collisions or any incidents in the high seas. Furthermore, the duty to rendering assistance to the distressed person is reiterated in various international instrument conventions such as UNCLOS 1982, Article 98, SOLAS Convention, Chapter 5, Article 33, or Salvage Convention 1989, Article 10, and etc. The shipmasters, when is near of the distress situation or following them collision with other vessels or ships, when found any person at distress, shall rendering assistance to these individuals without put her vessels or crew or passengers to danger situation. Hence, according to this convention regulation, the action must be followed under the logical approach of the shipmaster in the distress situation. The shipmaster, however, is responsible for determining whether or not there is a risk to their vessel. What is the logical risk in these cases? And defining danger as a broad term includes collision, elisions, groundings, fire, and other similar events that may be in danger of the safety of the person on board. Therefore, each case will vary, and judging a master decision is difficult. As per my experience at sea, it depends on several factors, including the shipmaster's experience and knowledge, the vessel's characteristics, the weather, the current at sea, the nature of distress occurring on other boards, the depth of the water, and the ship's draft. And understanding and assessing the situation is difficult. However, for the creating the one normal situation or creating the or improve the confidence per master, the YAMSAR volume 3 can be helpful in this regard, and that's it aims to improve vessel unification and coordination for SAR operation and the SEN. Before I continue, I shall explain the maritime search and rescue operation meaning. Under international law definitions and the IMO definition or in its instruments, which also is reflected in the YAMSAR manual, the term maritime search and rescue operation refers to an operation that provides assistance to anyone in distress at sea, irrespective of their nationality, status, or circumstances in which they are found. In fact, distressed individuals are at serious risk of threat to their life if assistance is not provided. So that is the distress situation definition. I can refer that if we're not rendering assistance, the life will be at risk. Today, the International Aeronautical and Maritime Search and Rescue Manuals, YAMSAR manuals, and the International Convention on Maritime Search and Rescue Operations, 1979 SAR Convention, they both established one proper procedures and framework for conducting appropriate SAR operations. And IMO said all states shall ensure that all vessels under their flags have a volume 3 of YAMSAR manuals on their boats. The International Aeronautical and Maritime Search and Rescue Manual, or YAMSAR manual, generally published by the IMO and ICAO in 3 volumes. This provides guidelines for a command, aviation, and maritime approach to organizing and providing search and rescue service. It adopted in 1999 and revised and replaced the IMO Merchant Ship Search and Rescue Manual, or MERSAR, and the IMO Search and Rescue Manual as the IMO SAR manual. primary objective of the International Aeronautical and Maritime Search and Rescue Manual, Volume 3, with the name of the mobile facilities, is to assist vessels and aircraft in performing SAR tasks and improving the coordination, unseen coordination functions, and assisting in the emergency situations. And it is considered that the followed by the rescue units, aircrafts, and the ship's masters. This manual reiterates to shipmasters that the duty to rendering assistance is underlying standing traditions at sea and based on the humanitarian considerations and values provision of international law. And uh, and they must assist others in distress at sea whenever they can safely do, and without puts in danger their vessels and current passengers. Thus, the following urgent action should be performed by any ship after getting distress call signals or other emergency information from another vessel at distress, either directly or through the relay. That vessel should be confirmed receiving the distress message, and also, if possible, collect all information related to the distressed craft and vessel, such as the position, nature of the distress, or number of the crew or personnel on board, the type of the assistance required, and the type of the cargo, and etc. Also, according to instruction, shall maintain a continuous monitor on global maritime distress signal systems equipment, GMDSS equipments, and the shipmaster must be post additional lookouts to assess the situation. Also, contact with the nearest rescue coordination centers in the coastal area, and pass all available information to the rescue coordination center and sub-centers of coastal area, which that's designated by the convention, SAR Convention 1979. Requirements. And what is the duty of shipmaster for preparation both of the vessel according to Young's manual instruction and maritime practices? The vessel on its way to rescue a distressed individual or a vessel should be prepared for the possible SAR action, including the necessary need to retrieve or recover the distressed individuals from survival craft or the water. In this regard, the master of the vessel en route to the scene should evaluate the situation and the dangers they might run into, including risks such as the leaking the cargo, fire, and etc. Information should be obtained from the distressed vessel or another stations, or even the rescue coordination centers at the coast area if necessary. In the preparation procedure, the shipmaster will evaluate the situation, arrange our facilities as needed, and put them to use as necessary to assist those who require assistance. And these facilities are maybe life-saving appliances or the medical facilities or arrangement, and also the firefighting devices such as the fire extinguishers. Anyway, the assessing situation is important and case by case will be different. For instance, rescuing vessels must examine the potential risks and needs when the distressed vessel is on fire. In the event similar such incidents, which is cargo was on fire and no cargo was condensate gas, and in this case, the captain of SAR units or salvor and crossing vessels shall see the appropriate firefighting means and method of the method and character or maneuverability of their own ships. Otherwise, another mistake could create another disaster or casualties. In this context, all decisions must be recorded in the log books, and if even the shipmaster shall couldn't proceed for the rendering assistance, again must be submit the reason and logical reason in the log book as requirements. The duty of a master after rescuing survivors, since a rescue operation is defined as retrieving the persons in distress, providing for the initial medical or other needs, and deliver them to the safe place. And also, when we embark, the people in distress at sea in the boat shall treat them with humanity and the various international instruments, which also added as amendment to the SOLAS and SAR Convention. Also, as the shipmaster, after recover the survivors, must be contact with the, another authorities, particularly rescue coordination centers and main RCCR rescue coordinated center. When the nearest RCC is not responded, they shall try to contact another station or coordination centers. Or if impractical, again, the other government agency that might be able to help must be contacted for provide assistance or deliver the that's survivors to the shore. Anyway, main question arises: where is the safe place that requested under the international instruments? The IMO Resolution 2004, following the Tampa incident, the other one amendment to SOLAS and SAR Convention try to respond to this question. And accordingly, as a definition in this context of a place where the survivor's life is no longer in danger, wherever their basic human needs, including food, shelter, and medical needs, can be provided, and transportation agreements may be made for them to their next or final destination. Place safety could be on land, on board rescue units or another suitable ships or facilities at sea that can act as a place of safety until survivors are disembarked at their next destination. And anyway, it should not be assumed that a ship is a safe place just because the survivors are no longer in imminent danger while already on the board. Assisting ships may lack the facilities and tools necessary to accommodate more people without risking its safety or providing adequate care for the surviving. The ships could release from the geodestination. Other arrangement can be arranged even if it can safely accommodate the survivors and may act as a temporary place of safety. Hence, the Amendment 2004 to Solace requested the party to coordinate and cooperation and work together to ensure the shipmaster provide assistance and assistance by embarking people in the distress at sea and also release from obligation with minimum deviation from the intended course of the ship and ask them states the cooperation with the shipmasters. Shipmaster obligation towards this person and thrive during SAR operation. Actually, SAR operation do not include looking for and recovering the bodies. However, it is occasionally essential for handle the remains and the body in the recovering human body or dying on the board, the vessel, or the SAR facility, according to the Yamsar manual in the Volume 3, they mentioned it also. The way should be prepared for the each person. The death certificate should be included full name if possible, and as well as the location, time, and or other necessary information. The waybill should be written in the national language of the SAR facility and also the English whenever possible. In this case, the master of the ship must immediately notify the rescue coordination center or other authorities. Although the international instruments or obligations do not impose obligation for finding the body of the deceased person, from an ethical and human perspective, it could be particularly significant to be able to find the remains of someone who has a capacity, particular because their family. For example, after motor tanker sanction incidents and when the whole crew passed away, some of the families still do not believe the crew had died in that incident, and still they are waiting for the family member that could come back again to the country and home. Another part is challenges of shipmaster and rescue operations. As a shipmaster, we are the first to arrive with there was in the distress situation have a various concern and which the person in the lands or land dwellers are not aware or they cannot imagine about these issues. In this context, we can solve into the important issues: safety, security, seaworthiness, and commercial concerns. And all of these separately are significant for the trade at sea. For example, one the number of individuals rescued by the commercial vessel often outnumber its crew, for example, particularly for rendering assistance to migrants and refugees at sea. This could make hard the operation or unsafe the SAR operation, particularly especially during poor weather conditions. Also, the type of the vessel is important. For instance, merchant vessels are not often designed to easy approach and maneuver toward much smaller boats, which are managed by unskilled individuals when confronted with distressed refugees. Also, these vessels, the merchant vessels have a high freeboard, and that is also important. For example, motor vessel King Jacob case in 2015, the April 18 of February 2015, the Italian Coast Guard asked this ship to rescue the one fishing vessel with 27-meter length overall and on board with 800 refugees at the distress situation. This was approached, and unfortunately, because of the erratically approach to the fishing vessel that's collided with this vessel, and the refugees on board panicked and shifted to one side, and the vessel already capsized. In this disaster, just 28 people reported have survived, and more than 700 people died in this tragedy. And also, the shipmaster may encounter other problems during the rendering assistance or lack of the facilities. So the facilities just arranged for the small number of crew, for example, the foods, medicine, water, fresh water, and etc. On the other hand, also that lack of cooperation with the rescue coordination centers also is another concern in the case of the rescuing the refugees for deliver them to the safe position or safe places. Also, related to the safety, we can the shipmasters, imagine the shipmasters crew put their own life at risk when they bring in the refugees on board. And that can impact the health and safety of the crew and the ships. Particularly, it's possible that the crew exposed to contagious disease and subsequently be quarantined on the vessel or not permitted to enter the states of water, or as occurred during the pandemics or unknown diseases such as the outbreak of COVID-19. Accordingly, most coastal states take extreme security measures. Also, in 2014, some states banned the ships from entering the airport that were suspected to carry infected persons during the West Africa Ebola outbreak. These kind of preventive measures are accepted by the international, particularly because of the related to the security of the coastal states and states already, as it's mentioned in Article 1921 and 33 and 42, the UNCLOS 1982. So, in this regard, we can refer to Metropolitan Western Copenhagen in September 2014. In this case, at least one passenger was suspected of being affected by the Ebola virus, and its captain requested assistance delivering him to the Malta, and Malta refused to accept because of fear of outbreak of the Ebola in the Malta. Also, in the case of rescuing the refugees, the shipmaster may also encounter hostile or armed acts or insecurity position. For example, the refugees on board the Tampa, that's threatening to commit suicide if not altering to the Australia, and if they disembark them in the Indonesia or alter to the Indonesia side, they will kill themselves. Additionally, seafarers working on the merchant ships are not trained for contact with these people or nor experienced in this situation. And in general, managing these stranger people or strangers rescued people is challenging since they can be risky to damage the ships and its properties and cargo as well. Thus, along with that's the deviation from the main course and delay in the reaching of the planned destination next to the damage of cargo and the safety and security of the crew. This is well complicated, and out of the delay and deviation from the intended course for rendering assistance, which is not bring the reliability for the shipmasters, and that is accepted traditionally. For example, in the case of Scaramanga in 1880, the judge mentioned that the deviation to purpose of saving a life is not always only a liability for the ships, and also in the Haugen with rules in Article 4, the rule 4 also, the state and deviation is in saving or attempting to save a life or property at sea, or any reasonable deviation shall not be deemed to be an infringement or breach of these rules or of the content of carriage, and the carrier shall not be liable for any loss or damage resulting therefrom. However, SAR missions can occasionally be difficult and expensive, while the ship insurance might cover certain costs, and depending on the type of insurance policy, a lack of adequate insurance may expose the ship owner and the cargo owner to heavy financial, along with the commercial losses. For example, assisting may entail the loss of profit or damage or loss of markets or customers. The customers and markets not waiting for you or not saying that because of you saving people will wait for you. They're thinking about their profits. And an assessment of on major European clubs insurance policy reveals that the most of coverage include a few particular costs associated with rescue operation or landing of rescued refugees, such as the fuel insurance and the part fees, wages, salaries, and stores and provisions. And they not cover the hull policy, the damage for cargo or damage for the ships, and they are other properties. Actually, as we can see, the rule of 3.6 on the PNI club rule. And delay is the normal when you facing to the distressed people, to refugees at sea. As example, we can see the Tampa case or the Salmis in 2013 or Capris in 2014, some of them because of the lack of cooperation of the coastal states or rescue coordination centers or coast guards, some because of the lack of cooperation the refugees itself. Such as the Capris case, the refugees didn't cooperate well with the captain. Penal policy toward the violation of duties by the master regarding the SAR operation emerging trends in the national jurisdiction. Governments had imposed penalties for negligence of masters providing assistance under the domestic laws, especially following the formations of Salvage Convention in 1910 and then Collision Convention in 1910. Although the Salvage Convention provision did not include penalties for failure to assist and penalized for failure to assist a distressed person, proposed to its party to take legal action as outlined in Article 12. And requires high contract parties to take preventive measures under their domestic laws to fulfill the obligation to rendering assistance at sea. As an example, for the state of Iran, India, and the UK and the US have made it illegal for shipmasters to fail to aid persons in distress under their local laws. Accordingly, today in the UK Merchant Shipping Act, we can see they imposed a fine maximum of £5,000 and 2 years in prison, and may also their certificate of masters and officers in charge cancelled or punished and or suspended by a court order in this context. Or in Indian Merchant Shipping Act 1958, in section 436, penalized the master negligence in rendering assistance in various circumstances. When vessels are near distressed persons and without any justified reason fail to assist them, their master will be punished with a maximum 6 months imprisonment and 1,000 rupees or both. In this context, according to section 370 Part B, when vessel with justified reason failed in following their obligation to rendering assistance, the master certificates or certificate of person in charge may be revoked or suspended. Or in the U.S., following the 1910 Convention, the U.S. enacted the Salvage Act in 1912 and supported the assistance duty by penalizing failures to assist without logical reasons. Section 2 of the Salvage Act provides punishments for shipmaster or any persons in charge who, without justified reasons or neglect to render assistance to distressed persons for maximum of $1,000 or 2 years imprisonment or both. This practice today reflected in the Title 46 the U.S. Code 2. Additionally, under Section 7703 of the U.S. Shipping Code, seafarer's certificate might be cancelled or suspended for misconduct or negligence or for failing to comply with the regulations. And according to the Iranian Penal Code, and refusing to assist the injured and removing the risk of death in 1977, anyone who present at the position of a distress and fails to assist a distressed person is subjected to the imprisonment, the maximum 2 years, and also pay compensation. Furthermore, the certificate of master or any person in charge could be revoked or suspended in the case of omission or neglect to conduct their duties under Iranian Maritime Acts 1964. A comparison of four related states approaches indicates the penalties, particularly fines, need to revise it, particularly in India, Iran, or the United States. In addition, the maximum prison sentence in India is 6 months, which seems insufficient. Nevertheless, there are few cases reported against shipmasters worldwide. There are 2 cases reported in the U.S. courts. In the U.S. Navy WTO incident in 1988, Marshall Code ruled against its commander and dismissed him from his position in the U.S. Navy. And in the Washer case in 1933, the court denied the plaintiff's claim against the ship owner because the 1910 convention prohibited ship owners from being held liable for a master failure to assist to rendering assistance. The actually the both Salvage Convention 1989 Article 10 and Collision Convention of 1910 Article 8 exempted ship owners from liabilities, and although the domestic laws may take a different approach, such as the Indian law in the Merchant Shipping Act in 1958 mentioned that the ship owners may also be responsible. At the end, as we see the rendering assistance to distressed people, let's say, is an obligation under both international customary rules and under the ethical review, and also under international conventions. And masters may confront of some challenges in this context, and cooperation of rescue coordination centers in this context is extremely important. Thank you very much for your attention, and again, I must convey special regards to the organizer of this session, particularly the University of Jahan and Professor Rabia Temsamani and her colleagues. Thank you very much.